FM, Mabaruma, Madia, Aishalton, Bartica, and Oriella. 95.5 FM in Essequibo, 97.1 Beta FM in Anai, 105.1 FM in Linden. Wherever you are, we have you covered on the Voice of Guyana, the nation's station.
It is 21 hours 4. Of course, we say a very good night to you and welcome down to Police and You, another edition, and this the 10th day in the month of August 2021. The name is Stan Gouveia, Mike Side, keeping you company until just about 4 minutes after the 10 o'clock hour, 22 hours 4. We're tonight, what we're going to be doing is we're discussing everything court. And no, not running to the place where you pay some monies and you get certain things and credits, and you decorate your home or offices. We're talking about legal matters, issues before the court, and there are two types of courts, I believe. No, three types, I believe, in Guyana. The main focus where most persons would have issues or incidents known as the lower court or the magisterial district. So that is what we're going to be discussing tonight, and everything there. What happens? You can give us a call on 2264762 later in the program to ask your question. Or you can send your question via WhatsApp on 6320147. You can follow us right now on Facebook. That's at the Ghana Police Force, either on Facebook or on our YouTube. As we get into tonight's program of the Police and You. Without further ado, what I want to do right now is actually introduce our guest for tonight. And I think she's certainly not a stranger to many of us who are who've had experience, as a matter of fact, of being in the court system. When it is when it is that you've had a matter that you've had to have tried as a defendant, or also as someone who has had a situation where you've gone to be a witness or any of that sort. She's been a prosecutor for a number of years. I think I've known for more than a decade it was. And she is now the court superintendent. So without further ado, let me just say a very good night and a big welcome down to our guest for tonight, the court soup, none other than that's Division 4A right here in Georgetown, not other than Assistant Superintendent Miss Shellon Daniels. Welcome to Police and You. I think you've got to come a little closer to my mic. Let me see if I can get you clearly. Yes.
Thank you, Stan. Good evening, and thanks for having me.
All right. Now, first off, welcome to the program.
Thank you.
And when we speak about the courts, given that you've got a wide understanding and background of it, I did mention that there are most likely three. I know we've got magistrates, then you've
We
got
have the
high court,
magistrate, we have the high court, we have the full court, you have the sexual offences court now, and you have the appeal court.
and the appeal court.
Yes.
And
We
then,
have
of
the family
course,
court also.
family court. And then, of course, then you've got the CCJ,
Yes, which is our
which is
final court.
of Jersey. But most cases usually,
Starts in the magistrate court.
and quite a number could end right in the magistrate's courts
Yes,
too.
the summary matters are what we term as the hybrid matters, which are also indictable matters, where the AJ and slash the summary disposal is applied for by prosecutors and it is granted by the magistrate, and those matters completed in the magistrate court. Some, some such as the break and enter and larceny robberies, just to name a few.
Or well, I know you just said you just called a term there that a lot of persons may not necessarily know when you said the AJA. If you could get
Now, when
into
we're
some
talking about
details
the
about that.
AJ, the AJ is the Administration of Justice Act, which gave the magistrate the power to try these break and enters, robbery and arms, of robbery with aggravation, even burglary and those type of matters in the magistrate courts. They are hybrid, they're what we term hybrid matters, which are triable both ways. They can even be tried as well before a judge and jury, where the
Hmm.
penalty is much more, as opposed to the magistrate court, which give the magistrate the latitude of imposing a penalty between 1 year and 5 years, depending on the circumstances and the nature of the offense at the time.
You did mention that that is where any case starts
Yes, in the
in
magistrate's
the
court.
magistrate's court. And when we talk about one of the things that evidently that really scares a lot of people is, having to hear that they have to go to court, whether it's a traffic offense that they have to go to court for, um, some misdemeanor or a serious offense, uh, any matter, and they have to go to court. They feel that this is above them, this is beyond them, and they're going to be deluged, they're going to be lost. For a person, particularly first time, especially if it is that they're accused, let's say, of a minor offense, having to go through in the court system, explain how it works.
Now, the first thing, once a person is alleged to have committed an offense, be it a summary offense, that person is being interviewed by the investigators. He or she would have been told that they are going to be charged at some stage for the offense. So by that, they should be preparing the person's mind for what is expected of he or she when it gets to the court. And I know for a fact that for a time for certain things, not only the court would send shivers down persons. Because even myself as a prosecutor, a young prosecutor, I remember standing in the court and your hands trembling and these things for the first time. And I know that there are colleagues today that still go through that kind of trauma. So the thing of it is that when you go to the court, do nothing, fear nothing. The court can only convict you once the evidence is presented and convincing and persuasive before the court. Says there's nothing for nobody to be scared about. The magistrates are creatures of statute and it deals directly with what the law states. At times it may not be pleasing to one side, but that's how it goes.
That's how it goes. Now, when you talked about this trembling, would you say it comes also from that perception that some people have out there that prosecutors are not as equipped as those lawyers who are defending clients in the court?
I would not want to say prosecutors are not equipped. Prosecutors are exposed to training tremendous training. That is also the DPP chambers is there to assist junior prosecutors. I would have benefited from that as a very young prosecutor, from a corporal coming up right up to my current rank. So what prosecutors need to do, and I would encourage them from time to time, is read a lot, read more, because most of the time these lawyers, they come, sometimes 90% of the time they bluff, and they watch at you and they underestimate you. I can talk from personal experience. You know, just see me, I might look few, but at the end of the day, nothing to laugh about. Once I stand my
Mm-hmm.
ground, that is it. You understand you? And as the good saying say, prepare. Failure to prepare, then that is exactly what you're going to experience as a prosecutor.
Is there also some like intimidation tactics? That's in cases where, as a prosecutor, you are going up against a lawyer, and in some cases, some lawyers with some sort of known repute. Um, do you find that in some cases they try to do intimidatory tactics?
Yes, they do. Defense has their job to do. The
Or
prosecution
that's
have their
it's all
job
fair
to do.
game, you'd say?
Yeah, the thing of it is that you prepare, know your offense that you require to prove, get your elements, prepare your file well in advance. So when, and the thing of it is that the prosecutor duty is much harder than the defense, because the defense only looking to create gaps in your case, whereas you have to analyze or assess what the defense may be coming with. So you have to prepare for your case as well as what the defense is coming with to counteract what they're coming with, right? And rebut their defense. So if you're not fully prepared and know your file, you can't just, as a prosecutor, pick up your bag today and go to court and expect to win cases. That is not going to help you as a prosecutor. And that is one of the things that I'm encouraging the young prosecutors under my guard currently now is read, study the files, prepare a list, and at least track your file within 48 hours so you know exactly. When I went back to the court soup office, I would have resuscitated what we call the orderly rooms. So you bring in the witness, which will relax your witness and prepare your witness. It saves time and it relaxes the witness. So when he or she goes to the court on the court day, they knew exactly what to expect, as opposed to taking a witness off guard that you just see them for like the very court morning, the name called, then you come and said you rush them through the statement. It don't happen like that. Some witnesses are a little slow, say from briefing the witness in advance. It prepares you as well as the witness for what is to be expected. You may not know what defense is coming with, but you can give them an idea as what is expected of them. So it's all about preparation, case preparation, and managing your time as well.
And you just mentioned prepping witnesses so that you would be able to have at least a reasonable execution at court. You've had experiences with hostile witnesses, and if so, how do you go about dealing with those?
For me, I would consider hostile witness as a last resort because one of the things a hostile witness is one who will turn against you, somebody that is hostile. So the thing of it is that prosecutors have many options. You have cases where you can either seek leave of the court to have the witness further be refreshed, and if the witness still demonstrate the same attitude, the negative attitude, or come prepared to change the story or tell lies, then you can go on the best option for me, which I would have used umpteen times. Ask the court to deem the witness a refractory witness. A refractory witness is not necessarily a hostile witness, but it may be a witness who stands in the box and refuses to answer questions posed to them. And it is always the prosecutor's duty to make the application for the court, be it hostile witness or refractory witness. And the refractory witness is one that I would have used on several occasions, and I could safely say to you it worked. So I encourage prosecutors to utilize that instead of deeming a witness hostile, because when you deem a witness hostile, it damages the entire evidence and the case for the prosecution. Whereas when you ask the court to deem the witness a refractory witness, then you gain. The court now has the discretion to remand a witness for 7 days. If when he or she comes back and they still want to refuse to give the evidence, then the court could send them for further 7 days, and a 7, and a 7, and a 7, until he or she decides to give the evidence. And I know I would have had instances where 7 days would wake up and the magistrate, as recent as last year, had to ask the witness the other day, you could not have remembered, just slow down, I'm writing. So I would not advise prosecutors, younger than I am, to deem witness hostile, but you can use the other options that are available to you, and it is in the law. The criminal procedure offenses makes provisions for you to make the application for the witness to be deemed a refractory witness. So that is it as it relates for me with hostile witness.
So the other term that people use also is perjury, and
Perjury.
that comes up quite a lot. And with that comes some sort of threat. You did mention with that term that you used, if it is that you can have the person uh, detained for 7 days. How do you, or how does the court then determine if a witness has perjured him or herself?
Well, again, it goes back to the prosecutor. The prosecutor must and should be following his or her case, because the witnesses would have given a statement well in advance before he or she would have been summoned to testify. So basically, when you're leading witnesses, you lead them from their written statement. So from the time you find that the witness is going off track, you draw it to the court's attention. Now, perjury is a criminal offense which attracts a sentence. Once the prosecutor observed that the witness is basically would have been sworn to speak the truth and diverted from speaking the truth, you draw it to the court's attention, and it is the magistrate in cases of perjury who caution that witness as it relates to the offense. They can stop the trial there and then, hand it over to the police. Investigation launch, charges laid, and the very evidence, the written one that you would have given prior to coming to court, as well as what you would have given upon oath, is now become evidence, and it is tendered against you.
So there are some people who say, as a matter of fact, it's just about 21 hours 21 here on the Police and You, in case you just joined us. We are here with the Court Superintendent of Regional Division 4A. That's Assistant Superintendent Shellon Daniels. For those of you who might have just joined us, and you can also participate in the conversation on 226-4762 should you have a question. But coming with that, there have been many instances, court superintendent, that we would have seen in some sections of the press, where some persons who would have been accused and taken before the courts have said that the statements that they had given were done under duress. They were either beaten or it was forced out of them, and that is not, it is far from the truth, or they were forced to give a confession. How does that impact the success of a case when such an allegation is made? That's one. And two, is it oftentimes that case?
Well, I'll take the latter first. Now, most of the time, a defense or a defendant or through its counsel will allege police brutality. And when those allegations are leveled, well, it indeed impacts the case for the prosecution, but that is not the end of the case, because in the magistrate court, or I should say in the magistrate courts, the magistrate would conduct what is called a voir dire, a trial within a trial,
Right.
to determine the circumstances, and not only would they allege police coerce or police this and police that, they would also say they never give the statement. I would have had instances where they claim they never give the statement, they never sign it, and so on and so on. So at the end of the day, the magistrate take the objection, take all that would have been said by the defense surrounding the circumstances of taking of or giving of the statement, and the magistrate now conducts what we call a voir dire, which is a trial within a trial to determine the voluntariness of the statement, and most of that. But I would encourage detectives or CID ranks during the taking of statements once they know that the accused person is willing